Hello everyone. In this presentation, we will deal with the relevancy of admissions under sections 17 to 31. Sections 17 to 31 deal with relevancy of admissions and confessions. Admission means a voluntary acknowledgement as to the truth of a particular fact. However, section 17 defines admission in a wider sense. According to section 17, an admission is a statement, oral or documentary, suggesting an inference as to any fact in issue or relevant fact made by persons and under the circumstances mentioned in sections 18 to 20. Admissions may be self-serving statements or self-harming statements. Self-serving statements are those which serve, promote, or advance the interest of the person who makes them. Self-harming statements are those which harm or prejudice or injure the interest of the person who makes them. Self-serving statements are not allowed to be proved subject to certain exceptions for the simple reason that they enable persons to manufacture or create evidence for themselves. For example, A files a suit against B alleging that he has borrowed 1000 rupees from him and that he had defaulted. B denies the fact that he had borrowed the money. Prior to the filing of the suit, A makes a statement to C that B had borrowed rupees 1000 and he has not paid it. A wants to prove the statement made by him to C. This statement is self-serving as it serves only his interest. On the other hand, where A alleges that B borrowed 1000 rupees which B denies, A wants to prove the statement made by B to C that he borrowed 1000 rupees from A and he could not repay it. The nature of this statement by B is self-harming statement. B is making the statement which is detrimental to his interest and hence it can be proved against him. Admissions need not be addressed to any particular person. Admission made in a state of soliloquy, that is, while talking to oneself, can also be proved. Further, admissions can also be made by signs and gestures. Silence can also be deemed as admission provided the person has an obligation to speak and he does not speak in breach of that obligation. Admissions may be formal or informal. Formal admissions are made deliberately with a view to dispense with other proof. Formal admissions are also called judicial admissions and are allowed to be proved under section 58 of the Act. Informal admissions are usually made in the course of casual conversation in ignorance of the possibility of their being used in the future litigation. When parties make an admission of fact, it amounts to waiver of proof of such fact. That is, the opposite party need not prove those facts, but admission can operate as a waiver of proof in the course of judicial proceedings only in case of formal admissions, but not in the case of informal admissions which are made casually. Now, what are the conditions for the admissibility of admissions? Admissions of which evidence is sought to be given must relate to the subject matter in issue. They must be in the nature of self-harming statements, that is, it must go against the interest of the maker. Admissions must be made by persons and in the circumstances mentioned under sections 18 to 20 of the Evidence Act. The admissions have to be in clear and unambiguous terms. Now, who can make admissions? Under section 18, a party to the proceedings or an agent to any such party can make admissions. Parties to suits who are suing or are being sued in a representative character can make admissions. Persons who have any proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement in their character of the person so interested can make admissions. Similarly, persons from whom the parties to the suit have derived their interest in the subject matter of the suit can also make admissions. Under the Evidence Act, admissions can be made by party to the proceeding and the proceeding can be civil or criminal in nature. Hence, plaintiff and defendant in a civil case and the prosecution and the accused in a criminal proceedings can make binding admissions. A complainant in the case of non-cognizable offense or prosecutrix in a rape case is also in a position of a party to criminal proceedings and can make admissions. An admission must be an unambiguous statement of the party. It can be proved against the party making it and not as against others. An admission made by a party in an earlier suit can be used against him in a later suit, whether the proceedings are between the same party or different parties, and whether they are criminal or civil. An admission made by the witness of a party does not bind the party, agent of the party. The principal is bound by the admissions made by his agent when he is regarded by the court as having express or implied authority to act on behalf of the principal. Members of partnership are bound to each other as principals and agents, and the admissions made by one can be proved as against the other. Admissions made by a partner can be proved against the partnership firm also. The parties, attorneys, and advocates can bind their clients by admissions in civil cases on questions of fact. Admissions made by the wife or husband will not bind the other spouse unless the statement of admission is made by one spouse deriving interest in the property of the other spouse. However, admissions made either by wife or husband can be taken into consideration against the husband or wife as the case may be, provided such statements of admissions are expressly or impliedly authorized. A statement of admission made by a person suing or being sued in a representative character shall be admission, provided such a statement is made while the party making it held that representative character. Persons with a representative character include trustees, executors, and administrators of will. Statements made by persons who have any proprietary or pecuniary interest in the subject matter of the proceedings are admissions if they make a statement in their character as a person so interested, and if they are made during the continuance of the interest of the persons making them. In a partnership, a statement of admission made by one partner shall be binding against the other partners, since the person making the statement of admission has proprietary or pecuniary interest in the partnership property. A statement of admission made by a person shall be binding against the party to the suit who is deriving his interest in the subject matter of the suit from him. For example, A, who sold his immovable property to B, makes a statement that the property in question sold by him to B is subject to a mortgage to C. This statement made by A is binding on B since he derived his interest from A. But the statement has to be made before he parted his interest in the subject matter of the proceedings. Now, the general rule is that an admission made by a stranger shall not be binding on the parties to the suit, but sections 19 and 20 are exceptions to that rule. Under section 19, admissions made by persons whose position or liability is to be proved would be relevant as against the parties to the suit or proceedings. Under section 19, where the position in life or liability of a party depends on the proof of the position or liability of another person, any admission made by such person would be relevant as against the parties to the suit. To take an example, A and B are jointly liable for a certain sum of money to C, who files a suit against A alone. A raises an objection that he cannot be severally made liable and that B should also be joined as a co-defendant in view of joint liability. An admission made by B as to his joint liability is relevant as between A and C. Section 20 is another exception to the rule that an admission made by third persons shall not bind the parties. Under this provision, statements made by persons to whom a party to the suit has expressly referred for information regarding a matter in dispute can be proved against such party. For example, the question is whether a car sold by A to B is in good condition. A, when asked by B about the condition of the car, tells him to go to see his mechanic and ask him as he knows about it. C's statement about the condition of the car would be relevant as against A as admission. The matter must have been referred for information by the party against whom the admission has to be proved. Where it is contended by the plaintiff that the defendant may be examined and the suit be decided on the basis of the defendant's statement, the statement made by the defendant would be relevant as admission against the plaintiff. In order to make a statement admissible under Section 20 as admission against the party to the suit, it is necessary that the reference must have been made for information in relation to the matter in dispute. The referee must have made a statement in relation to the matter referred. Section 20 applies only to those statements made by the referee in relation to the matter in dispute which has been referred to him by the party for information. Where B asks A as to the condition of the car and A asked B to go to his mechanic C and ask him about it, C's statement as to the price of the car instead of the condition of the car would not be relevant as admission. A statement made by the referee in response to the reference made to him by the party to the suit in relation to matter involving question of law cannot be received as an admission. There cannot be any admission on question of law. Where the statement is made by a referee after the reference is revoked by the party, the same cannot be proved as admission. Section 21 deals with conditions for proof of admissions. It is an important provision which lays down the conditions and circumstances in which an admission can be proved. Section 21(1) lays down the basic principle that admissions are relevant and may be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest. In other words, self-harming admissions can be proved by the party, but not self-serving admissions. Section 21 mentions 3 exceptions to the above principle, and under these exceptions, self-serving admissions can be proved by the persons making them. The first exception states that an admission can be proved by or on behalf of the person making it if it is of such a nature that it would be relevant as between third persons under Section 32. Section 32 deals with relevancy of statements made by persons who cannot be called as witnesses. The illustration to the section says that A, the captain of the ship, is tried for casting away the ship, that is, allowing it to drift away from its course or route. A wants to adduce evidence of the logbook maintained by him, wherein details of the cruise and the course followed by the ship are recorded in the ordinary course of business for the purpose of proving that he did not cast the ship away. As the logbook is maintained by the captain himself, the entries are self-serving statements and would have been barred under the opening part of Section 21. But as the entries in the logbook are made in the ordinary course of business, they would have been relevant under Section 32(2) between third parties if the captain was dead or not found, etc. Section 21 makes an exception in this case for the reason that the statement in the logbook, though a self-serving one, might be true as it satisfies 2 safeguards of Section 32(2), that the entry was made in the ordinary course of business and the book was kept in the ordinary course of business. The captain also did not know at the time he made the entries that they were self-serving, and the entries in the logbook were made at a time when the controversy had not arisen. However, the admissions are only declared to be admissible by the section by lifting the bar, but they are not conclusive of what they state. The second exception to Section 21 states that admission can be proved by or on behalf of the person making it if it consists of a statement as to the existence of a state of mind or body, provided that such a state of mind or body is an issue or is relevant. The statement is made at or about the time when such a state of mind or body existed. The statement was accompanied by conduct rendering its falsehood improbable. where A is accused of receiving stolen property knowing them to be stolen. He offers to prove that he refused to sell them below their market price. A may prove these statements, though these are admissions, because they are explanatory of the conduct influenced by the fact in issue. The third exception states that a self-serving admission may be proved by its maker if it is relevant otherwise than as an admission. In other words, what is inadmissible under section 21 may be admissible under some other section, and the bar of section 21 will not apply to such a case. This provision is incorporated out of abundant caution because it goes without saying that if a statement is relevant otherwise than as an admission under some other section of the Evidence Act, such a statement will be relevant under the other section. For example, a person is seen running down a street in an injured condition and crying out the name of his assailant. He may prove his own statement as it accompanies some conduct and explains the fact of injury. Now, Section 22 of the Evidence Act echoes the best evidence rule contained in Section 64 of the Evidence Act, which says that documents must be proved only by producing primary evidence, except in cases mentioned in Section 65. So long as the original document exists and is capable of being produced, it being the best evidence must be offered in proof of its contents. Oral admissions as to the contents of a document can, however, be proved by a party by showing that he is entitled to give secondary evidence of its contents under Section 65. When the original is lost or destroyed, the party proposing to prove its contents may resort to secondary evidence under Section 65 and offer an oral account as to the contents of such lost or destroyed document. Where the genuineness of the document is questioned by the party against whom it is to be proved, oral admission made by such party as to the contents can be proved under Section 22. For example, A files a suit against B alleging that B borrowed 1,000 rupees by executing a promissory note agreeing to pay the money at the stipulated rate of 6% interest within a period of 6 months or on demand. B made an oral admission to C that he executed a promissory note in favor of A for 1,000 rupees and agreed to pay the money at the stipulated rate of 6% interest and within a period of 6 months or on demand. Here, A, in order to prove B's liability, cannot offer the evidence of oral admission made by B to C as to the contents of the promissory note. The promissory note, being the best evidence as to its contents, must be produced to prove B's liability. If the original promissory note is lost or destroyed, oral admission made by B as to the contents of the document can be proved. If B alleges that the promissory note was not signed by him or that his signature has been forged, he can prove the oral admission made by B as to the contents of the promissory note. Under Section 22A, oral admissions as to the contents of electronic records are not relevant unless the genuineness of the electronic record produced is in question. Under English law, oral admissions are allowed to prove the contents of the document. Now, statements without prejudice are dealt with under Sections 23. In civil cases, an admission is irrelevant if it is made upon an understanding between the parties that the evidence of it is not to be given. The admissions covered by this section are referred to as admissions made without prejudice, that is, without prejudice to the rights the party has. Suppose the parties to a litigation want to compromise. If a person wants to purchase peace, there must be a little give and take. Now, one of the parties may be willing to admit his liability to a limited extent or to be satisfied with the decree for a lesser sum than the amount claimed in the plaint. Communication will be sent to the opposite side containing these terms. If they are agreed to, all will be okay. If not, the suit will proceed. If evidence is permitted of the negotiations, it will be unfair to such a person as his case will be prejudiced. The court may think he himself has admitted liability, or that he himself had admitted that he will be satisfied with a lesser amount, and the court unconsciously may be influenced by such concessions. Therefore, evidence of such negotiations is not permitted. The explanation appended to the section states that any barrister, pleader, attorney, or vakil who can be compelled to give evidence of any matter under the proviso to section 126 is not protected, even if it is made upon an express condition that it shall not be used in evidence. Under section 126, if an advocate's help is sought for the crime, or if an advocate discovers that a crime or fraud has been committed by his client after his employment as advocate, the advocate can disclose as witness what his client told him or what he discovered. The client cannot say the disclosure was made to the advocate on an understanding that evidence of it will not be given. The client cannot claim protection of section 126 or section 23. Section 31 states that admissions are not conclusive proof but may estop. So when one fact is declared by the Evidence Act to be conclusive proof of another, the court shall, on proof of that one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. According to section 31, admissions are not conclusive proof of matters admitted, but they may operate as estoppels under section 115. It means that the maker of the admission can adduce evidence to disprove his own admission, to show that what was admitted is not true, or that he made the admission as a result of fraud, coercion, mistake, etc. In other words, an admission is rebuttable by its own maker, except where it operates as estoppel under section 115. Even if the maker of the admission does not seek to rebut it, and even if his opponent seeks to rely on it, section 58 goes a step further and states that a court may insist on proper proof of the facts admitted. This is about the rules pertaining to admissions under section 17 to 23 and section 31 of the Indian Evidence Act. Thank you.